A very good afternoon to all of you, and thank you all for joining us today. And a very important and a very hot discussion, I would say, on a subject which affects all of us together. So, Fiki, with the help of our partners, EY and NDA, are happy to present this webinar on a very important subject of Digital Personal Data Protection Act, navigating it, and of course, understanding its impact for its industry and how to prepare it well. It is being taken under the leadership of our task force, which is on data privacy and security. And we are thankful to our leadership, our co-chair, Mr. Shrikant, and of course the other chair and the co-chairs and our additional Director General, Ms. Jyotivij, who have been helping us out in curating this webinar. So from FICCI's perspective, we are happy to present that. Now, what's the subject and how it affects all of us? While many of you would know about it and would have been reading it in the newspapers very often, I would just say that let's start with the word digital, and we know how it has affected our lives, how the technology has affected our lives, how it has changed the way we are living it today. Be it any part of the things we do, digital, we are connected. So when we talk about digital, there comes an important area called your personal data, the data, which is the new, I would say, asset which is there and which needs to be taken care of in the rightful manner. To take care of the same, on 11th of August, to change the history of the digital history and the landscape of our country, Government of India introduced Digital Personal Data Protection Act. Now, what this act and how it affects us is something which our members and I would say the esteemed speakers will deliberate today. They'll take you through on the various aspects of it, the legal side of it, the compliance thing, how it needs to be taken care forward. And from FICCI's perspective, this is our first of the discussions. I would say in terms of formal, we have been having various discussions with our members. And we had made various contributions to the submission of the bill before this became an act. And we have been working with the government hand to hand in various areas. And our commitment stands same. And we would be taking step forward with the help of our members and with the government to execute and to implement the same. While the act is coming to picture, various rules and regulations are in making. So as FICCI, as a task force, we will be taking forward these, again, discussions with the help of our members. I would just say that the bill actually gives you I would say, empower you more strongly digitally. It shows government's commitment to rest the power in the person it's supposed to be, which is you, which is me, which is everybody. So be it the business, be it the individuals, be it anybody, digital personal data is something which is affecting all of us, and we need to know how it is being taken care forward. So as in the words of the government, it's a SARL, which is basically simple, accessible, rational, and actionable law, which has come into picture. And it, of course, rests on major 7 principles, which I'm sure our speakers will take it forward, which takes care of each and every thing which is required to safeguarding your interest. And it gives you a right on various things to know about what is your access to the information, giving you the right to correct it, of course, to change it at any point of time or get it deleted, to know how it is being processed, to give you a right to nominate a person in case there's some mishappening or you are unable to do that, and even to go in for grievance redressal. So these are the various things which this act empowers each and everybody. And it, of course, helps the business to tune their, I would say, processes in the similar manner. It, of course, positions India in a very stronger way, having this framework globally when we are already known as a digital powerhouse. So with these words, I'll stop here, and I would request now our co-chair, Mr. Shrikant Rajagopalan, to please kindly share his opening remarks. How do you see it from FICCI's perspective, this bill taking India's landscape, digital landscape to next level? Over to you, Shrikant.
Namaste, and thank you for that very kind introduction, Sarika ji. You actually made my job so much easier. As a very brief introduction, I have the privilege of serving on the FICCI's working group on privacy and data protection. We've been engaged in this activity for over 2 years now. This bill, as it was called, has been through multiple iterations, multiple changes in scope and specificity. In fact, I still have to remind myself to call it an act and not a bill anymore. For 2 years, it's been going through multiple changes, but all of a sudden, within a week, I think that's the world record that any government would have set. It went through 2 houses of parliament, got presidential assent, and is now a gazette notification. So we finally a nation of 1 billion plus data consumers have a law, have an act which gives us the safety that we deserve as data consumers. So what I wanted to do was to spend the next 5 to 7 minutes in simply providing an overview, not diving too deep into areas of expertise that my fellow panelists have, but to give you a sense of what kind of feedback that we're hearing from business owners, what kind of questions are on top of mind, and how we should be really looking at 3 things. What is the scope of the law? What does it mean for me? And why should I worry now? I mean, fundamentally 3 questions that everybody asks. Is it, do I need to care? What do I need to do? And when do I start? So in, Sarika ji, can you just confirm that you can see the presentation on screen?
Yes, we can.
Okay. The slide is a little busy, my apologies, but I'll quickly simplify the key highlights that you may want to take away. The intent of the law is to minimize disruption in the ways of doing business currently. At the same time, driving that balance of driving the necessary changes in how data is collected, processed, stored, so on and so forth. The key outcomes then, the 3 key outcomes that the law seeks to establish is an ease of living for citizens, ease of doing business for corporates and startups and entrepreneurs, and the ability to really drive innovation in a very, very collaborative but safe fashion. And there are some specifics in terms of the applicability of the law. It applies to personal data in digital form. And each of these words is kind of important. It's not for non-personal data. There was a previous version of the bill which attempted to include that. This version of the bill, which is the Act now, is very specific to personal data, which is in digital form. And there is a nuance there. Suppose you submit a physical copy, let's say, of your bank statement to a sales agent to apply for a loan. That physical copy is not under the scope of the law. But the moment that is digitized, somebody, let's say, does a scan and then OCR extraction of that, the moment that data becomes digital, it is within the ambit of the law. The hope and the nuance there is that the fact that my digital data is protected encourages me to participate as a consumer more and more in the digital ecosystem and not remain data dark. So there is a nuance, and there is a specific reason why this applicability is so specific. Processing is allowed only for lawful purposes, and there is, from our research, a world first of the specific role of a consent manager in this whole data ecosystem. The specifics will come later in this session. And as you look at the applicability of the law, I think the first question that you need to ask yourself is, am I a fiduciary or am I a processor? The simple way to answer that question is, do you determine the reason or the specifics of what data is collected, why it is collected, and how it is processed? If you are making those decisions, you're a fiduciary, and therefore you are covered by the scope of the law. However, if you're simply, let's say, for example, a technology service provider who simply is, implementing the technology processes or the pieces of the puzzle for the fiduciary, you are a processor. You're not explicitly covered by this law. However, it's more than safe to assume that you are, as a processor, bound by very strict contracts and audit and controls by the fiduciary. Parental consent is a very, very hot topic in this whole regulation. I'm sure that for a lot of industries, this is going to be a very, very contentious issue in terms of how it is operationalized. Just today, there was an article in the Economic Times that potentially there are technology solutions like DigiLocker which would solve some of these problems. But this is again work in progress. If you're in a business which deals with significant cross-border flows of data, the only thing we can say now is watch this space. There is still a lot of thought and a lot of specifics that need to be sorted out. And the one thing that is obviously, the loudest discussion is that so-called check size of penalties, right? 50 crore is a starting point. For a lot of us, for a lot of startups and small businesses, that is almost an extinction level event. If ever, God forbid, we are charged with that kind of a penalty. So the message here has to be that this is serious business. The law is really, really serious in its desire to control how data is processed. Moving on, here is what I'd like to leave with you as thoughts and what you might want to take away and think through. Privacy and data protection has to be embedded in the DNA of any business which deals with data. Right? It's not just yet another compliance checkbox. I have done 1, 2, 3, 4 things. It is a matter of survival. If something happens and if it is proven that breach or that violation of the law happened either by oversight or by intent, then the size of the penalty and its severity can actually wipe out a lot of people. So please look at this as a survival toolkit rather than a compliance toolkit. And to me, I think the third and the more difficult mindset change is going to be the thing about data minimization. Right? Most businesses that I know are kind of happy with more data that they get. Right? Whether or not you need it, whether or not it's really needed for the purpose that you serve, mil gaya to le lena, right? And apologies for non-TV speakers, but that fundamental mindset has to change. If you don't need that data for offering that product or the service, don't collect. So the more the data you collect, the risk and the compliance overheads go up exponentially. So please keep this in mind. And the other question that I keep getting asked is, we just have an act which is taking so many years to put together. There is still time for the operational rules to come out, for the regulator to come out, for the data protection board to come out. Should I wait? Should I wait for more clarity? In my experience, these things take a lot of time. I've spoken with organizations who've already started on this journey of figuring out the path to compliance. And I've also spoken to companies who are saying, let's wait and watch. Once there is some clarity, then I'll start thinking about it. My humble submission to you is this is effectively simple, but can become fiendishly complex in operation if you start mapping your entire relationship with customer data right from the time that you solicit a customer to target her with a bunch of services and then store the data for the future. It takes a lot of reimagining and assessing your own processes to figure out a compliance strategy. I would even just the way that cybersecurity went from a distraction to a board level priority. I would believe that privacy and data security will need to go to the same escalation and actually be reviewed at a board level, no matter whether you're a 10-person startup or a multi-billion-dollar, big company. This has to be driven at a board level. So with that, I come to the end of my opening remarks. I hope I've been able to convey a sense of, it's never too early to start. And with that, over to you, back to you, Sarika.
Thank you, Shrikantji, and thank you for for letting the broad context know and everybody getting prepared that please be ready to change your mindset, start now and take it to the board level, this thing. So I know, I completely agree. There's something which we were talking about cyber a decade ago, as something has now become which is like part of every decision you take it. Something which the boards are actually now taking it seriously and working it as part of the strategic decision. So something related to data privacy and security is going to take it to the next level. For sure, this act is going to make those changes very pertinent, and industry and the businesses and the industries needs to be prepared well for the same. So thank you for your initial remarks. With this, we will move on to our next speaker, who is Mr. Huzaifa Tawala. He's a head international Commercial Law Practice Tech, Nitish Desai and Associates. Thank you, Josefa, for joining us today. And we look forward to hear your thoughts on the applicability of the bill and the cross-border data compliances, the topic which I'm sure many businesses are looking forward, something which you would love to share it with the MNCs, whether it's a global MNC or an Indian MNC, something which you are looking at it. So from NDA's perspective, we would love to know how you are thinking it is going to, how is it going to impact the industries, especially with the cross-border data flow, and how are you proposing the solutions for the same? So over to you, Josefa. We look forward to hear your thoughts. While we have speakers in the panel on board, just for everybody's announcement, we have more than 200 attendees who are right now viewing it. Audience, you're free to please post your questions in the chat box, and my colleagues will assist us. In the available time limit, what we can justify, we'll take a few questions with the panelists, but you're free to start posting it from now onwards. Over to you, Josefa. Thank you.
Absolutely. Thank you so much, Sarika, and a special mention to Srikanth. He's absolutely set the tone, very rightly so for this webinar, right? And just kind of granularizing on the two themes which I'm going to speak on. First and foremost is the applicability, and the second are the cross-border nuances on this subject. Now, as the title of the act goes, right, and as Srikanth said, we are still kind of grappling to call it with the act because it's been in bill form for so long. The second word of the act, it says it is the digital. So this is very important. The Digital Personal Data Protection Act. So the applicability of this act is only in relation to personal data in digital form, or if it's collected in physical hard copy form and then subsequently digitized. Now, this is a very important aspect, that if companies are processing personal data only in physical form, then the act does not apply. Ultimately, there has to be a digital nexus. That is one. The second questions, which we have actually the theme of questions which we've been getting, and post October 11th, it's actually been really busy for lawyers, not complaining though, is that what are the various types of scenarios in which the applicability of the act is. So for example, obviously the act will apply when Indian companies are processing data of Indian individuals. Now, the second or third question comes is that, would the act also apply where foreign companies are processing data of Indian residents? Or the other angle is where Indian companies are processing data of foreign nationals. So I'll split it down into three buckets from an applicability perspective. The first case scenario is that the act will apply in relation to Indian companies processing data of Indian individuals. So that's the first tick. The second tick is that the act would also apply when Indian companies are processing personal data of foreign nationals, because the act unfortunately does not define an individual or a data principal who's an Indian resident. It just says it's an individual / natural person. The third case scenario is the most unique, and it also kind of segues into from a cross-border perspective, that the act has extraterritorial applicability. So what does that mean in simple terms, right? In other words, it means that if foreign companies are selling goods and services to Indian residents, and those foreign companies, in relation to selling those goods and services to Indian residents, are processing or collecting data of those Indian residents, then the compliances under the act would also be applicable to those foreign companies. So there is an extraterritorial nexus which immediately gets triggered. Yes, there are certain gray areas on this cross-border angle, that would the goods and services need to be actually received in India for the extraterritorial application to get triggered, or just the moment if Indian residents are sharing, say their name, phone numbers, or email addresses to foreign companies, even for receiving services outside India, would it get triggered? So these two use cases need to be tested further. Probably we'll have some clarity on the rules, but the bigger takeaway for all our audience is that the act has extraterritorial, applicability, which essentially covers foreign companies' compliances in India if they're collecting Indian residents' data in India. Now, the logical theme on the cross-border applicability basis the extraterritorial, points which I just mentioned, is that what about cross-border data transfers, right? This has been a pet topic for a lot of industry players, a lot of lawyers, a lot of industry organizations, and FICCI has also been very active on this front, that the way companies are structured in India is that usually there are some sort of subsidiaries who are operating in India, and then those subsidiaries kind of share data with their overseas affiliate, and the data is shared with the overseas affiliate is for a consolidation perspective, for HRM management, payroll processing, many overall group functions. So what does the law are these cross-border transfers permitted? The big news out there is that yes, they are permitted as of now to all countries, unless and until any territory or country is blacklisted or restricted. And that will be notified by the government. Now, we don't have a list of any of blacklisted or notified countries as of now. So as of now, we assume that data can be shared to foreign companies. And this also can be done by the Indian companies who have intercompany agreements with their foreign companies. They can share it. But of course, there are certain bells and whistles which need to be taken care of, when the data is shared. In essentially, compliances would need to be largely mirrored while sharing the data overseas. Now, one interesting point which actually comes, and I'm sure when the rules kind of get elaborated on this front, that since the Act has extraterritorial application, which means that foreign companies are bound by compliances while collecting data of Indian residents. Now, there could be a situation where some country ends up getting blacklisted. Now, say some land bordering country of India ends up getting blacklisted, which means that data cannot be shared to those countries. Then in those situations, we could be looking at a scenario where Indian residents may not be able to purchase digital online goods or services, because if the data cannot be shared for any online transaction, the bare minimum would be name and phone number or email ID or address. So these sort of unique situations will actually pan out, and we need to wait and watch if there's further guidance on the rules. But these are my two bits in terms of the broader applicability of the Act and certain nuances which need to be factored from a cross-border perspective. Back to you, Sarika.
Thank you, Zefa. So I'm flooded with questions. I was just looking at the questions and it took me a while. So I think let's take the questions once we are through with Mini and Lalit also, because there are things which are coming up, which is immediately, for Zefa, immediately it's going to be related to GDPR. So I'll come back to you.
Yeah, so I have been very mindful of the clock considering the questions, and that is why I've kept it short and crisp. Back to you.
Yeah, thank you. So, Mini, now over to you. We would love to hear your thoughts, and I'm sure, and I'll request you and Lalit also to be mindful of the time, because we can take up the audience questions. There are lots of things which are really showing the good interest. So from your perspective, we would like to know this privacy for MSMEs, your address is on that subject. Then how do you see the whole subject of the Act having an impact for the MSMEs? And when you talk about the privacy, how do they need to prepare themselves? And there are various levels of MSMEs. So what's your advice to them in this regard? Over to you, Mini.
Sure. Thanks, Sarika. Is my screen visible?
Mini.
Sorry, I was on mute. Yes, it is visible. And for everybody's benefit, Mini is a partner with EY. Over to you, Mini.
Sure.
I think your screen was visible. Have you stopped sharing your screen?
Okay. Is it visible now?
Yes, it is. You may like to make it a full screen.
I'm doing that. Is it in full screen now?
Yes, it is.
Yes, Mini.
Super. Okay, great. And thanks, Sarika, and thanks to Fiki to give us this platform. So if you look at it, everybody is questioning what's the Act about, and my previous speakers have spoken about certain clarity around the Act. But there is a large fraction of organizations that is wondering to say, how does it apply to the micro, small, medium enterprises as well? Right now, if you look at it from a MSME perspective, these are companies which may not have too much of revenue turnover, right? So in a lower investment, not more than 250 crore. But if you look at the count, we're looking at over 63 million MSMEs in India alone, where of course a larger chunk is micro, but there is a significant amount of small and medium enterprises, which typically would come under the gamut of this act. And if you look at it, of course, that touch point is huge, right? Because more than 113 million workforce, they contribute to 30% of the GDP, and of course, a large contribution is towards manufacturing. So, given this, and if you were to take just some examples of these businesses that come under MSME, a lot of them services businesses, whether you have replacement agencies, educational institutes, your scanning companies, even in terms of, your beauty parlor and creches where, you have children's data, x-ray clinics, labs, etc. So there are multiple such businesses. While small, they actually deal with a lot of personal data, and some of them could be data with respect to individuals, consumers, as well as maybe other third parties or the entire agent ecosystem. But some of them also deal with things like children's data or health data as well. So that kind of makes it all the more reason to kind of sit up and say, okay, so what does it mean for companies like these? Now, we know about the applicability, but if you look at it from an MSME perspective, obviously a large chunk which is not dealing with digital personal data so far are outside the purview. Additionally, if you look at it, there are certain exemptions provided. Now, one key exemption is where the government has said that they may notify with respect to certain startups. Now, you will have MSMEs that would qualify to be a startup who've been around for not more than 5 years or have a revenue within the startup boundary as well. So there again, while it's not clearly mentioned that they would be exempted, but yes, there is a provision to say there would be notifications coming in where those exemptions may come in. So that's something that MSMEs should watch out for who lie in the startup bucket. Now, if you look at some of the challenges, when it comes to these organizations, they're so focused on the core business that we're looking at. So really compliance is the least on their mind. It's really about saying, how do I get my business running? How do I get profitable? So given that, and they're already probably some of them operating on very thin margins with limited manpower. So obviously resource is always an issue. And here we have an act, of course, that talks about obligations, that talks about some focus that needs to be brought in. We need to identify who could be taking that role within the organization of looking at what is required to be done, how much of it is applicable, and what do I need to do from a data protection perspective for the personal data. Now, if you look, another element which is key is the lack of awareness. Like I said, since the focus is on core business, the sensitization because of the sheer volume, and they operate across multiple regions. It's not all in the urban sector, right? So it's significantly also available in the rural and semi-urban sectors. So the kind of awareness that we're creating in this forum is probably something that really needs to reach that level, or those kind of enterprises that exist as well, so that they understand what is it this act about and what really applies to them. Now, in terms of data, again, it's pretty unstructured. There may not be really norms around how are they storing or processing, because obviously they're in for business. The whole governance angle probably is not as mature in these organizations as compared to maybe larger setups. So for them, if we have to look at things like consent management, how would they really do it? For them to be able to record every consent, be able to fulfill the obligations based on the consent provided, any changes in consent, how will they set up that mechanism really to kind of enable this is going to be a real challenge. And we'll talk about what can be done as well. But essentially, what should the notices be? What should I draft? What should the language be? I need to have it in multilingual. So what should it be? How will I put in those measures in place or protection terms in place is something that is that these organizations will need help with or would grapple with. Further, of course, there will be limited amount of automation as such. So are there manual ways of doing it? So from a compliance to the act point of view, given that the business and the setup is reasonably smaller, can we achieve all of this maybe through manual mechanisms, right? So these are some of the challenges that they are grappling with. Now, if you look at it from a perspective of we've talked about the key parties involved, the requirements. So what does it mean from an MSME perspective? Again, the Data Protection Board is and will be the nodal body for MSME companies as well. So this is where, there will be registrations required. This is where, in case of any review, in case of any penalties, this board will be applicable. When it comes to being a data fiduciary, now in case of an MSME as well, if we're dealing with personal data, if we are not in the exemption category, and right now, there isn't much about saying if there will be further exemptions from a perspective of MSME perspective. However, there is a provision in the Act which says that the government may notify what is applicable to whom and when. So from that perspective, we understand that the government will take probably a practical stand to say that from an MSME perspective, probably give a larger amount of time frame, while that's not currently present, but probably give a larger amount of time frame and go lenient in terms of the based on the exposure and the risks associated. Now, again, however, if we do fall in the data fiduciary category, we'll have to ensure that we put in the right amount of safeguards, we provide the notice, we have the right lawful basis or the grounds for processing. What one needs to assess as an MSME, however, critically is, would we be a data processor, and where are we data processors? Because in most cases, you will see an MSME could be a data processor more than a data fiduciary. And in that case, while the Act may not be directly applicable to us, as an MSME, we'll have to ensure that we really read through what contract clauses are we signing with the data fiduciary and ensure contract compliance, which in some cases could get onerous. So having the right negotiations would also be important. But do look out for those contract clauses that could come your way, even if you're a data processor and not a data fiduciary. Now, from a MSME perspective, not too many may fall under the significant data fiduciary category. However, you may qualify the criteria if you're handling larger volumes, if you're handling sensitive data. So maybe the labs kind of setup or education or institutes dealing with children education, etc., may come under the category if there are volumetrics involved. And there again, the rules are still awaited. But once we have the rules, we should assess to say, is there anything qualifying us to be a significant data fiduciary? Because if it does, then there are obligations which could get a little onerous for MSMEs, and hence we should assess very clearly to say, do we really happen to be significant data fiduciaries? What is still important to be noted from an MSME perspective is, like I said, you could be data processors and you could be data processors to other significant data fiduciaries. Hence, ensuring and hence that onus of ensuring security, safeguard of that personal data that the other significant data fiduciary company or entity has trusted us with also is extremely important. Ideally, as an MSME, we should request the data fiduciaries or the significant data fiduciaries to make the technical measures available to us so that the data is available to us in a secure manner, and we are not overburdened by the responsibility of putting in some of those technical controls. So that's another dialogue, that's another conversation that we should have as processors with our data fiduciary companies to say how they can extend the technology layer, the security layer to us as MSMEs as well. From a notice perspective, of course, we're aware of the various obligations. Now, consent, of course, becomes critical. What is more critical is the consent manager layer if we are data fiduciaries. Now, here again, what an MSME should do and should focus on is explore some of these existing mechanisms that are available for consent management. So rather than maybe building something on your own or kind of trying to grapple with how you will manage consent in a transparent manner and effectively able to service, there are various tools and technologies and players that would be available, which you can actually latch on to in a faster and more effective and cost-efficient manner as well, who can then manage your consent for you. So as MSMEs, I think that's something that you should definitely look out for rather than kind of trying to build it yourself. We've talked about legitimate use. As per the Act, there are various elements where where you don't need to take consent, and there are elements around legitimate use. From an MSME perspective, the ones highlighted clearly is something that you should take note of. So if someone's voluntarily provided information to you, or a lot of these MSMEs could be helping out in terms of emergency situations, epidemic kind of situations, or disaster scenarios. Now, there again, if you are doing a processing, if you are a entity that's kind of involved in any of these scenarios, you will not to need to take consent, but you will have a legitimate use as a grounds of processing. So consent is not everything. There are ways and means that data can be processed as long as we fall on this category. And of course, for the purpose of employment, again, that's a legitimate use. So, if you're worried about employee data that you're collecting, then that again comes under legitimate use as long as it's being used for the purpose of employment. So hence, not to worry on the consent bit for employees as well. Now, for businesses, for MSMEs, of course, dealing with children's data, I'm just reiterating what my previous speakers have talked about, because this does get onerous. So if I am an education institute focusing on children's data, or if there is children's data that is being collected by me, we have to ensure that we have verifiable consent. The good thing, like Josefa mentioned, there is a DigiLocker provision that's being talked about, or was talked about earlier as well. So look out for some of these. We are looking at the government probably making things easier. We are looking at something which is going to be more practical, that as small and medium enterprises we can adopt and make use of. So it's not something that you'll need to build. A lot will be available that you can leverage, that you need to really look out for and probably seek advice on. So broadly speaking, multiple aspects. What are the grounds for processing? We need to understand that. What is the requirement for notice and consent? What are the tech org measures? And here again, how can we leverage probably the data fiduciaries aspects if you're processors, or try and do things which are more effective? So there are measures available in place where you don't really need high-end technologies, but just pure plain storage mechanisms, security measures which are available in some cases, maybe even in terms of smaller setups that have made these things enabled, which MSMEs should look out for. So we've talked about some of these aspects already. So broadly, what is it that we need to do as MSMEs quickly? What are the now, next, and beyond steps? These are just very simple ones. So from now up to the rules come out, as an MSME, let's assess our applicability, right? How much of it are we really data fiduciaries versus processors? And are we processing data for any significant data fiduciary? That we know, for example, if it's a telecom organization, if it's a banking organization, typically they will be significant. So are we really working for any of those? What are the digital personal data touch points that we have? So, quickly just assess what are the personal data touch points, how does this data flow, both internally and externally. So the entire data mapping exercise. Now, this is quick. This is something that you can probably complete within a month or two max. And it will give you a good visibility of where you stand. You may not really need to over-engineer things, because once the rules are released, that's when we should look at to say, okay, do we qualify to be a significant data fiduciary? Who will then be the designated lead for data protection in the organization? What is the bare minimum framework, policies, and processes that we need to put in? Let me tell you, a lot of larger organizations also, when they embarked on GDPR as an era, they really didn't have all the evolved technologies or mechanisms. There is a good set of bare minimum that you can work back with, which is extremely cost effective and light on the pocket as well. You do have providers who can help you with that. Then in terms of consent management, we've spoken, leverage what's available existing, and then you can accordingly initiate implementation. Once the compliance is effective, of course, you'll need to assess and update if there are any changes in the applicability, and look at eventually also adopting technologies. Like I said, there are very cost-effective technologies also available that one can make use of. What is extremely key, however, from now to till the end, till whenever we're in existence, is the ongoing awareness and sensitization. So that is something that we will need to ensure that we are coming up to speed. There are enough channels available like this as well, which can help you create that awareness within the organization and within the industry at large. So that's what I had. Sarika, over to you.
Thanks, Minnie. So thanks for highlighting the 10-pointer agendas for the MSMEs, and of course mentioning the timeline and how they can prepare themselves in next 3 months, followed by another stage, and then of course the compliance thing which comes in. So with this, we would come to our next speaker, Mr. Lalit Kalra. He's again a partner with EY. Lalit, over to you for your address on comparison of this Indian Act with the leading global regulations. Of course, that's a question many of in the audience would have, and they have actually put up also in the chat, but we can take up those things, but first we have a clarity from you on your presentation. So over to you. How do you see India versus the other regulations in the similar domain from other countries?
Thank you, Sarika. Good afternoon, everyone. And thank you, Minnie, for the details on the how is it applicable on the MSME and the other fellow audiences. The task that I have is to show a comparison between different privacy laws that have been existing in the world for quite some time and what the India Data Protection Act brings to the table. So just for everyone's benefit, the first data privacy or data protection law was launched by Australia in 1988. And then UK followed suit by the Data Protection Act or the Data Privacy Act in 1995. And since then, there have been a plethora of regulations which have come in. In the last few years itself, almost all countries across the globe have either launched or released a data privacy law or amended their existing one. Till date, the three most prominent ones that we have today essentially are EU GDPR, which is European Union General Data Protection Regulation, California Privacy Rights CPRA or CCPA, what most people would call it, and our own India Digital Personal Data Protection Act. So these are the three ones that are being talked about today. GDPR, for all practical purposes, till date has been considered the gold standard when it comes to privacy, considering all the areas that it covers. So we will today in the next 15-20 minutes, we'll see how the India Digital Data Protection Act stands against the leading laws that we have already available across the globe. So let's first look at applicability. Now, Josefa covered about applicability and Mr. Shrikant also covered a bit about applicability. EU GDPR specifically says that it is applicable on processing of personal data, which is wholly or partly automated or is a part of a filing system. The CCPA applies to organizations which are doing business in California and to all the data, personal data that is getting processed, including automated means. The Indian law specifically talks about digitized personal data or non-digitized but subsequently digitized. So that's the difference is essentially from a CPRA. CPRA focuses on all types of data, including offline data. GDPR covers all data in scope, but specifically focuses on data which is forming a part of the filing system and not specifically calling it as a digital. So I can have a scan copy available with me, but if it is not a part of a filing system, that will not fall under the purview of GDPR. Under the Indian IT Act, any information which I have digitized falls under the purview. So it is more stringent with respect to GDPR, but in comparison to CPRA, it leaves out the offline data. From an extraterritorial applicability perspective, the applicability across the three laws is similar. EU GDPR is applicable to companies which are processing personal data of EU nationals in the territory of EU. The same is the case with the California organizations doing business in California and processing personal data of people in the territory of California. The same is applicable to Indian DPDPA, wherein it is applicable to companies which are providing services in the territory of India. So from a territorial applicability perspective, all three have the same applicability. Now we talked a lot about penalties. This is the earlier versions of the Act. The first version of the Act bill, which came in, was on the lines of GDPR, which talked about 2% or 4% of the global firm's revenue and maximum up to 20 million euros, whichever is higher. So the amount of 4% or more than 20 million was a big number for organizations and was one of the scary bits which enforced companies to go for the compliance on GDPR. While when we look at CCP or CPRA, they've taken a different approach. Instead of doing it at a complete organization, it was done for individual breaches or individual violations. So even if there is a breach, the values are lower, but the volumes of breach will ensure that organizations comply with the law. The India Act essentially allies with the philosophy of GDPR and overall penalty. So there are different provisions for penalty. When you do not comply with the provisions of law, there is a penalty of INR up to 250 crores. There is a penalty if there are not technical safeguards implemented and so on and so forth. The unique part of this is between GDPR and California and across any other law, there is never a penalty on the data principle or data subject, as they call it. To ensure that companies are not taken for a ride, to ensure that organizations are given a fair representation, there is a penalty on data principles also if they do not fulfill their obligations. And the obligations are clearly called out in the Act that a data principle needs to follow. The main objective of this is to ensure that non-frivolous class action suits don't start happening on companies, which is what happened when GDPR came into existence. And there was a lot of burden on the overall ecosystem to the companies as well as the judiciaries to ensure that those are managed. So this is to ensure that and cleanliness. Now, all the three laws essentially allow children data processing. The difference between the three is in the number of years, the age criteria which has defined, whether it is 16 or 13 in EU. However, the different states have the authority to define a different age number that they want. All three talk about parental consent, but the Indian law goes a step further here. It talks about a verifiable parental consent. Now, in GDPR or in CPRA, organization can still take an email address and go ahead with the parental consent. Under the India purview, the organizations will have to verify that the consent is coming from the parent and not the child who is giving the consent as a parent. The other pieces, the India Data Protection Act disallows processing of children data if the organization believes that it could impact the harm of children or a behavior monitoring of children or ads which are specifically targeted for children. Those are prohibited under the Act. So all the organizations which are processing data of children under 18 years of age will have to relook at their consent mechanism, will have to relook at their processes to ensure that the children data is processed in line with the requirements of the Act. Now, the other key mechanism which is being often talked about is the breaches. In today's environment, there are times when the organization will face breaches. Some they will be able to prevent, some they will not be able to. So there are different timelines which have been defined by the laws. The GDPR specifies 72 hours notification to the supervisory authority as well as data subject if applicable. CPRA does not specifically define a timeline, and so is the case with the India Data Protection Act. It does not specify a timeline, but based on whatever we've seen and heard till now, it would most likely be aligning itself with the requirements that certain has already defined with respect to a 6-hour breach notification timeline. So an external breach would be required to be notified to the data protection board as well as data principal if applicable, most likely within 6 hours. Now this is interesting point on cross-border data transfer and one of the most talked about. So the initial versions of the law which came in talked about data localization for India, and which was met by a lot of protest from the industry that it would stop the growth, it would not act as an enabler for innovation and so on and so forth. Keeping that in mind, the data localization has been done away with. And across the 3 laws, none of the laws talk about data localization. But the European GDPR and the CCPA essentially focus on telling mechanisms by which organizations can start to transfer data outside of their respective geographies. So GDPR talks about standard contractual clauses or binding corporate rules, which allow an organization to transfer data and process it outside of the regional geography. The same is not applicable under CPRA. The India Data Protection Act takes on a different approach, wherein it says that the government would notify the countries where a data transfer is not allowed. So instead of giving a white list of countries, the government is working on creating a blacklist of countries where the data transfer would not be allowed. And therefore making it easier for the organizations to streamline the cross-border data transfer. From a notice perspective, across the globe, the globally accepted language is typically English, and it does not specify that organization should be providing or taking consent or notice in the local languages. But in the case of India Data Protection Act, it requires data fiduciaries to provide notice in English or in any of the 22 languages mentioned in the 8th Constitution of India. So to ensure that the organizations and the government is able to cater to the rural areas also where English is not a common language. So when it comes to data principal rights, all the laws, all the 3 give similar rights: right to be informed, right to access, rectification, erasure, right to data portability, and not automated processing. Now, there are differences across the 3. So for example, right to automated data processing is not available in the Indian Data Protection Act, or the right to sale is not available in GDPR or neither in the India Data Protection Act. Specifically on the India Data Protection Act, what is significant is right to nominate another person to exercise rights in the event of a death or incapacity. This does not exist in either CPRA or in GDPR. And in fact, specifically, GDPR does not clearly talk about whether it allows rights for dead individuals also, while the India Data Protection Act takes that into consideration and making organizations and giving more power to individuals. A right to grievance at redressal has been specifically called out as a right, while this is a mechanism is available in GDPR and CPRA, but here it is specifically called out, and there are timelines which are mentioned for grievance redressal. And if the organizations do not meet those specific guidelines, the data principal can actually go to the data protection board and raise their concerns and then take it further. The last one that I have is in terms of the key roles. The key roles, like Mini mentioned, are similar across all 3. So you have controllers, you have processors, and you have joint controllers under GDPR. It's similar, and DPO as well as under GDPR. Similar in CPRA, but CPRA does not have a specific obligation for a DPO. The India Data Protection Act essentially divides the controller into two: data fiduciary and significant data fiduciary. Both of them are fiduciaries, but at different levels. And there is no mention of a joint controller, which is specific under GDPR. The joint control as a entity does not mention or does not exist under Data Protection Act of India. The new body which has been created or identified is consent manager, which is to be defined and registered with the board and would help individuals manage consent and would help them to interface with the large organizations and ensure that the process for consent, withdrawal, and providing is streamlined. So this is keeping the population of India in mind and ensuring that everybody gets an equal opportunity to get their grievances and consents addressed. So those are the key points when it comes to a difference between GDPR, CCPA, and the India Data Protection Act. One key aspect which does not fit in any of this is, this is the only law which has referred to the data principle as she. Across the globe, none of the laws talk about she, and this essentially shows the focus and the strength that the government wants to empower females. And this is a brilliant example on the focus that it has. So this is from my side on the comparison between the three laws, and would be happy to take on any questions. Sarika, back to you. Thank you.
Thank you, Lalit, and very well said. And we were very happy that this time, first time the she has been referred in the act. And of course, one of the acts which is also focusing on the 22 constitutionally recognized languages, that all notices have to be their language. So these are the two important takeaways. In fact, that was one of the announcements with our Honorable Minister also made in the Lok Sabha when bill was introduced. So thank you for this. And while we have come with the end of the, I would say, the addresses, but there is, I would say, flood of questions. So let's start with the questions. And for the audience, we'll try our best to cover up as much as possible. We have another 29 minutes left. So we'll see if we can cover up as much. In case we are left out, please feel free to write back to us and we will get you the answers from the respective panelists. Please address it to the particular panelist you want an answer from, or we will happy to have further discussions with you offline as well. So we'll start with the questions. So I'll start with a question which talks about how do you foresee changes in digital landscape and India's position globally after the Data Protection Act? So Shrikant, what's your take on this one?
Thanks, Sarika ji. I think that's a very, very insightful question. There's a lot more nuance that the person who asked the question has than is evident in the question. Thank you for that question, whoever asked. If you look back at the last 5 to 10 years in what India has achieved in its digital economy, starting with the India Stack, starting with Aadhaar, Jan Dhan, UPI, and now eventually account aggregators and other digital public infrastructure. I think for the first time we have a working and scalable model where the government kind of co-funds and builds infrastructure and the standards and the guardrails around that infrastructure, and then just invites and allows private entities to build solutions and applications on top of it, right? And everybody knows the data. We are hoping for that month, I think this or next month, where UPI will process, 10 million transactions a day? I've lost count of, how many zeros they talk about. So what we're seeing is that India has shown how to build digital infrastructure for citizen scale. We are now in a position where there is a lot of interest where the same approach of public infrastructure in the digital world can be exported to other countries called the global south. So I think there is a lot of respect for what we have built for our domestic market. There is a lot of thought leadership and statesmanship, I think, that we are showing in wanting to offer this as a service to other countries. But what was a little illogical, in my opinion, is that we were kind of building huge, railroads without adequate safeguards. I mean, something as basic as a data protection law. Right? In very private forums, I've been, wondering why we've been putting things, almost back to front. I think this act finally nails that argument. It says that just like we're showing global leadership in infrastructure and services, we probably have, and to Lalit's point, I would say diamond standard in the data protection laws across the country, right? So I think the takeaway that I have is the India Act is intentionally written very simply and very, very at a high level, so that as technology changes, and as definitely will, the pace of technology change is going to only accelerate. The law doesn't have to keep going through Parliament and those processes for any change. Right? It is forward compatible. All that you need to do is to look at the applicable rules and the regulations at that point of time, and tweak the regulations to keep pace with market share. That's a far more agile and adaptable way of dealing with change, rather than having to relook at a law every time some change happens. Right? So my considered opinion is that this kind of ticks a lot of boxes in terms of a unified approach to market innovation, infrastructure building, legislation, and regulation that I think, people will look up to as India as a thought leader in this domain.
Thank you. So Diamond Act, forward looking, forward competitive, and makes India complete digitally. We had this DPIs, we had services to export, and now we have world-class, I would say, the security law, which is in place. So locks and checks and balances well taken care of. Thank you, Shrikant. With this, we move to the next question. There's a question, sir, if any privacy breach or security incident happens, as per this new law, do we, body corporate, still needs to follow the directions given by certain in 2022 for breach notification? What would be the steps to be taken care of in case of breach? Lalit, over to you. While you did mention about the certain and the 6-hour guideline, but you would like to maybe further expand on this.
Sure, Sarika. So like I said earlier, currently the Act does not specify a timeline. But based on whatever we've heard, whether the interviews from the minister or the articles which are being published and the discussions, they said, it has been said that it would complement the existing laws that are prevalent. And certain has already released the timeline of 6 hours and organizations are following it. So there's a highly likelihood that they would, both of them would complement each other and the timeline of 6 hours would continue.
Okay. Thank you. So we assume that the coherency would be maintained and the 6 hours would continue. Thank you. Next question. What is your take on the EU legislative branch analyzing international data transfers from the EU to India, wherein experts state that there are huge privacy concerns and India might not fall under the countries that have a robust data protection laws to transfer? Will this not impact businesses and create cumbersome compliance mechanism? Josefa, would you like to take that?
Yeah, that's a very, very interesting, loaded question. And let me actually give some inference and taking from what Lalit said on the comparatives, right, from a GDPR equivalent. Now, of course, the adequacy test under GDPR, where certain countries are identified as countries where adequate security safeguards are there, data safeguards which are there. Now, of course, India is yet to actually notify the sections of this law, and we'll await to see what European Union does from an adequacy perspective compared to India. But let me tell you that our law is not so different from a GDPR, and taking some very fact-specific examples. Like the GDPR, our data law, our DPDP, focuses on the quality of consent, right? Essentially, the consent needs to be free, informed, specific, unambiguous, simple. Now, this is also a bedrock from a GDPR perspective. And to just draw further parallel inferences, like take the redressal mechanism under our law, which is being proposed, right? We've essentially got a 3-tier redressal mechanism. We can first approach the data fiduciary, then we are looking at setting up an independent board, which is nothing but the data protection board. And even further, there is a redressal mechanism, which is the TDSAT under the law. Now, these sort of, staggered grievance redressal mechanisms are actually not there in the GDPR. In fact, our law, and, that was a good comment made by my co-speakers, that, processing of children's data seems slightly restrictive under law. And the language which has been used is detrimental effect on the child and so forth. Now, again, those sort of things are not actually there in the GDPR, and not, in addition to that, the main point is notification of breach notification requirements. Our law actually says that we need to inform the board as well as the data principal. In the GDPR, the obligation to inform the data principal is only dependent on the impact of the breach. Why I'm saying this, Sarika, is that though our law is kind of complementing GDPR, but if you ask me as a lawyer, it's actually going, in certain instances, it's going beyond the threshold of GDPR. So only time will tell from an adequacy test, whether we are notified or not. But irrespective of that, I want to also highlight one thing, right? Standard contractual clauses have been there, where European companies, before this law also came into place, have been enforcing it in our contracts. So I don't think that we will be looked at, or India as a nation will be looked at, whereby there is inadequacy. And I think we're in the right direction. I think the bar is being slightly raised in certain cases. And just to kind of complement Lalit's point on the timelines on the breach notification, and I think it segues into somebody else's question on that too. I'll just take that up, just joining it together. CERT is a separate law altogether. The requirements under CERT are very different, because those incidents need to be reported irrespective of a personal data breach. Reporting requirements of a data breach is only one criteria under the CERT Act. But under the CERT Act and rules, even if your infrastructure, your IT systems, routers, DOS, DDoS, distributed denial services, a lot of those things need to be reported, and the timelines, sometimes it's 6 hours on data breach, and sometimes it's not specified if it's a data breach. So short point being that these two are independent acts. Once, if there is an overlap, the general theory of law is the more stringent should prevail. But under the data law, the breach notification requirements, procedures need to be specified in the rules. Sorry, I just wanted to kind of sum up both the questions more holistically.
No, thank you, Zepa, and thank you for making that clarification that this data breach is one part of the certain advisory notification. So yes, that's something. And for reporting on 6 hours, that will remain. And in case of the breach, of course, the stringent would apply, the law would apply. So thank you for this one. With this, we move to the next question. How can consulting firms focus on implementation and auditing compliance with DPDP Act? Do we have a guidance document or standard for the same, like ISO 27701 or something? Mini, would you like to take that?
Sure. So there is quite a bit of material, in fact, floating around in terms of what needs to be done, what's the implication, what are the steps going forward. If you look at it, just if one has been consulting for laws such as GDPR, CPR, etc., you can really leverage the same set of methodologies for helping organizations comply with the DPDPA as well. In terms of awareness, there are multiple sessions getting created. In fact, there are training programs getting curated as we speak, which are focused around the provisions of the Act and what is it that organizations need to do. For consulting firms like us, broadly, since if you look at the Act, if you look at the entire methodology, it talks about doing an applicability assessment. It You will need to do a gap assessment. You will need to do then a design framework and then help in the implementation. The principles remain the same. There is really no change when it comes to the principles. So what we've been doing and how we've been advising our clients across the global privacy regulations is something that we can leverage here with the fine tuning with perspective of the act. So like my colleagues and my speakers have talked about, whether it's to do with specific verifiable consent for children, whether it's to do with multilingual language, etc. Those are the provisions that we'll have to ensure that in the design and framework and in the implementation, we are aiding the clients around. But there is enough and more material available. There are training courses available. But my advice would be, let's leverage what we've built, the volume of knowledge that we've built while providing services for the global laws, and leverage that to extend it to help organizations comply with DPDPA as well.
Thank you, Mini. And I think I'm again getting a question on the certain. So maybe Josefa, you would like to take it further on this one, while we have already clarified it. But there are two more things which is coming more on the same lines. So I'll repeat it, and maybe you like to cover it up. So the question talks about certain direction, which are related to reporting data breaches incidents. Request the panel to throw some light on how these legislations will interact with each other. So I think later more deep diving into both the things with the certain and our act would be important. So maybe Josefa and Lalit, if you want to add on anything post Josefa's comments.
Absolutely. I Lalit, if you want, you can take lead, or I can.
So essentially what we've covered till now would be the response to this is similar. Both certain and the DPDPA, and the DPDPA would essentially act as an overall umbrella law for various prerequisites and obligations that organizations would have to follow. And across the globe, whether it is a local, wherever there is a provision of a local law being considered, the stricter law always prevails. And in this case of certain, essentially the certain talks about 6 hours of breach notification once the breach is identified. So in our view, the same would be followed in terms of DPDPA as well.
Yeah, so I kind of broadly agree with what Lalit said. And, I was, and just from an academic perspective, I also want to share this insight. Now, the current act has a particular section 38, which actually is kind of, it's a juxtaposed sort of a situation. It essentially says that the provisions of the act, which is this particular act, will not be in derogation to any other law in force, which essentially in simple words means that you will not dilute or run down any other laws which are in place. So, taking Lalit's point here, if the for certain data breaches say 6 hours, which are largely, personal sort of data breaches, then the reporting requirements is 6 hours. Now, if the DPDP comes and says that the general reporting requirement time is 24 hours, basis 38, you will have to read it that the DPDP cannot run down or dilute the obligations of cert in, which means cert will prevail. But under this same DPDP Act, there is one additional line which kind of creates confusion, which we've been voicing it out to the ministry as well. It says that if there's any conflict with the DPDP, and I think Srikanth is aware of this, I think even he's been involved in some discussions, I can see a broad smile on his face. And just for the benefit of the audience, the other line in the DPDP, what it says is that if there's a conflict between this act, which is the DPDP, and a provision of any other law or which is in force, the provisions of the DPDP will prevail. Now, unfortunately, both these points which I mentioned are under the same section, which is 38, 38.1, 38.2. So one section says that you cannot dilute or read down any other law. And the other point says that if there is a conflict, the DPDP Act will prevail. But I think from an overall, these sort of acts which are very consumer and user driven need to be looked at it from a purpose perspective. And I look at it from a purpose perspective, the stricter should prevail. But again, interesting times, wait to watch how the rules come up, but great question asked by the audience.
Thank you, Huzefa and Lalit, and thank you for that clarification. Let's see what it gets notified in, especially when you talk about Section 38. So let's see. And the next question we come to, how does the Act regulate the processing of digital personal data, and how does it impact data processing companies? Mini, over to you.
Sure. So like I mentioned, from a data processor perspective, there is no direct obligation on a data processor under the Act, right? So if it's kind of left to the data fiduciary, but you will see a lot more stringent contractual clauses coming in, because data fiduciaries will ensure that any processor that's working for them, there's some sort of a back-to-back. Because at the end of the day, they will be responsible. The other element that you will see coming on data processors could be penalties as well. While again, under the Act, there are no penalties for data processor, but contractually, while there'll be obligations, you may have consequence management linked to it also. My personal estimate, this may lead to some consolidation of my data processing community, because if they have to put in the measures in place, they probably would need some investments around that. The other case also for a data processor to kind of represent to a data fiduciary is, why expose the data to us in insecure manner? Why not expose it to us such that it is secure? Give us access, don't give us data, right? Give us a secure access so that we can process it, but we really don't need the data copy coming to us. So the processor should, in their rights, if they're agreeing to stringent contractual clauses, then demand for mechanisms which allow them to process it in a more secure manner, and they can enable data protection rather than putting in another layer of security and investments to it.
Thank you. So that gives a good safeguard to the data processors. Our next question. So, Shrikant, I'm going to address this to you, and I'll try to kind of put two questions together. So what are the different ways to implement verifiable consent? How can we avoid consent managers being the single point of failure for users' privacy? And there's another question which I saw. What is your view on the removal of the deemed consent clause from DPDP Act?
Oh.
It may hinder several digital services. How will the industry adapt to it? And as a marketer, how should I use customer data and manage consent on my online forms? Over to you, Shrikant.
I could take half a day on this, but I will not. But okay, on the consent manager's role, and it's a very, very sharp question on avoiding a single point of failure or exposure. I can give you an example from the industry that I operate in personally, which is the account aggregator space, which is currently in the financial services domain. The account aggregator is a consent manager. It is regulated by the RBI. The design and architecture of the consent manager is to be data blind. All that a consent manager does is to uniquely identify, let's say, Sarika ji, and says that, okay, Sarika ji is now applying for, let's say, a loan at Bajaj Finance, for which Bajaj Finance has asked for 6 months of a bank statement, which he consents to provide from SBI, for example. All that I know as a consent manager is who is the data principal, in this case, Sarika, who was the requester of data, in this case, Bajaj Finance, who provided the data, SBI, and here is verifiable consent. At no point does the consent manager even look at the data pack. So in simple terms, in everyday terms, look at the consent manager as a registered post or a digital courier company, right? The fact that the right person has given the right data to the intended recipient and for the right purposes is something the consent manager takes care of. Already there are discussions which have started. If you notice, there is a central role for the consent manager in the India Data Protection Act, which I think, as Lalit pointed out, is very unique to the India Act. The good news is that we have a working mechanism already in the financial services business, which is the most stringent in terms of regulation. I think we have a great start in terms of replicating this to wherever there is a need for a consent manager, which is probably going to be universal. And by design, because we're data blind, there is there is limitation of that damage for a sentiment. The second question is about the deemed consent. As you can imagine, this has been a very, very controversial topic. One of the things that might come about is supposing you're sitting on a certain bunch of data from your existing customers, which you collected for a certain purpose. Right? In the example that I just gave, you collected my data for the purpose of processing a loan. Right? You cannot reuse that data to, let's say, offer me some other service. Okay? To be able to offer that service, you need specific consent for that use case. Right? So the removal of deemed consent means that just the fact that you got data till now from that customer for a certain historical purpose does not allow you to reuse that data for certain future unplanned purpose. If you think there is a business opportunity, there is a genuine need for that customer to avail a service, you need a specific consent for that purpose. It sounds onerous, I know. It sounds very, very operationally intense. We will have to wait, as other panelists have said, in terms of specific directives, specific regulations. And there is the good news is that the ministry has been very, very participative and inclusive in terms of hearing out industry sector. So when the rulemaking starts and when the regulations start, I think there will be some kind of a middle path that we'll have to seek between deemed consent and consent fatigue. Right? And the last question was around, as a marketeer, how should I use the customer data and manage consent? I think the first part, how should I use the customer data, kind of got addressed. I think one of the ways to address the consent in your online form is to kind of be very, very transparent in simple language in terms of what is the purpose for which you're collecting the data. I mean, all of us, simply click a button saying I agree, and life goes on. Right? I think that will be good. You have to be very, very specific and purpose limited in terms of what consent you seek, for what purpose, and for what period. So, I think the feedback has been from all panelists that please be, introspect in terms of how you can make it more intelligible for your customers and therefore be more compliant with.
Thank you, Shrikant. And of course, the question of consent and deep consent, like you mentioned, it continues, and we hope so that during the implementation, we are able to manage the expectations accordingly. One question maybe between Lalit and Huzefa. Lalit, you did mention, the audience is asking, the penalties which are being mentioned in the Act, do you think it is very stringent, it's very high? You did compare it with GDPR and the other acts, but the point is they're saying, how do you see it with respect to our country? So Lalit, first you, and then I come to Huzefa on the same, his comments.
Sure. Thank you, Sarika. So I have, this is more of an individualistic on my personal opinion. We always have an IT Act. For the last 20 years, IT Act has been there, and it talked about notice, it talked about consent, but the enforcement that we've seen individually has been very minimal there because there were no penalties. So would the companies be penalized 250 crores? The answer is very rarely the companies would be penalized 250 crores. But does it act as a barrier for companies to comply with the law? Yes. And in my personal opinion, such penalties should be there because it creates that enforcement boundary. It creates that fear in the minds of people that yes, there is a provision. If something does not go right, we may get penalized. So in my personal opinion, the penalties should be there, and to this extent. Huzefa.
No, wonderful inputs, Lalit, from your side. And I would just kind of extend to what you said, right? And going back, and I've been in discussions for several months with people on this, that the good part about this law is one is the quantum, and the quantum can always be debatable, right? Why is it so much? But I think the two broader takeaways, at least from my perspective, is that it is up to. So when you say 250 crores, it's not that somebody's going to be fined for 250 crores. Or when it says 50 crores, not somebody, it's up to. So it's like a graded thing. And I think more importantly, the act, and it is the board, the data protection board, which will levy the penalty. It actually lays down some great grounds. There are 6 to 7 grounds in terms of how will the board actually determine the penalty. So it's not like an ad hoc thing that somebody is breached and one orders given and penalties done. They've actually gone and said that the board needs to understand the nature and gravity of the breach, the repetitive nature of the breach, what is the gain or loss which has been caused to the person, what mitigation steps have been taken by an organization, and more importantly, is the penalty a proportionate deterrent to that event which actually happened. So I think the ultimate, at least in the way I look at it, to kind of sum it up, is that yes, the penalty thresholds are there, but I think the actual implementation by the board will be critical. That on an operational level, when these matters get escalated to the data protection board, and when a penalty is levied, what are the actual grounds looked at, or is it like hugely disproportionate? Then it would be a disaster. I think it has to be horses for courses in some sense.
And I agree with that approach, because that's something which our Act has really taken into consideration. It's not something which has come on an ad hoc basis, and we are having a proper graded manner to decide on the same. So I'll take last two questions, because we are almost 1 minute from 4:30 and the questions are still flowing in. So please bear with us. We'll come back session for sure with our partners. As of now, I will just wrap up with two more questions. I'll take up this question: what steps industry should be taking to educate their employees about the responsibilities under the data protection bill? Mini, your take on that.
Sure. So one thing, of course, organizations need to have started off the sensitization. In fact, we're already doing that for companies, where you start off from the board, from the senior management, and then ensure there is a top-down push as well. So while sensitizing the employees, please do not leave out the CXOs, the senior management. That's extremely important. What is also important is do not just stop at the employee. How are you extending it probably to the families, to the children, and to the senior citizens, more importantly, because those are the ones who probably may not be as aware or may miss out on certain elements. So again, as companies, as corporates, how can we join forces, not just to kind of create those programs for our employees? We do have LMSs, we do have the do's and don'ts that we should send out on a quick note to say these are some do's and don'ts as an individual, plus these are some do's and don'ts as a responsible employee as well, what one should follow on behalf of the organization. So as corporates, we have the opportunity to educate not just as a fiduciary or a processor, but also on behalf of citizens by large. The other aspect that I would really urge organizations to do is partner to see how we can create education and awareness within the rural segments as well. That's something that typically is getting missed out. So yes, for employees, while we put out the do's and don'ts, and the LMS courses that are available and the sessions that we are doing across the board, see how we can instrumentalize some programs for citizens at large as well, more in the segments of non-urban cities and towns as well.
Thank you, Mini. Of course, giving the responsibilities and everything as part of a responsible digital citizen, I would say that. That's something which you've just mentioned, be it an individual or a organization. So I will pose the last question, and I want each one of you to make your concluding remarks with that question. So the question talks about, what do you think could be the immediate do's and don'ts, which as an industry we need to be prepared when this act has come into picture? So please give your do's and don'ts specifically. So maybe Shrikant, I'll start with you, and then I'll go around with the whole group.
Okay, that's a very broad question, Sarika, but I'll do my best. I think the two do's immediately is to say that when in doubt, assume that the law applies to you, right? Assume that you are accountable. And the second thing that I would say is that make this an operating tenet, make this an operating principle that, it's almost like you do everything possible to make sure that before you close shop at the end of the day, you lock up your Fiduciary, right? And you make sure that your cash still is safe. Please look at data with the same level of sensitivity, the same level of, paranoia. What happens if your shop is broken into and your Fiduciary is broken? The same thing, the same mental model should apply to data. It can be as life-threatening to your business as, losing hard cash, right? So two do's. One is that make this almost an organizational DNA. And second is treat your data as almost on par as the, cash on hand. The two don'ts I would recommend is don't be greedy with data, right? Back to my starting point is with great data comes exponentially higher responsibility. Get used to a mental model of data minimization. So if you don't need a particular data point to offer a certain service, don't collect it, right? And the second don't I would say is, and this is very particular to a B2B environment that I come from. Usually you would look for a vendor in our parlance that should be, let's say, a processor, who's the cheapest and comes to the lowest cost, but maybe questionable data governance or compliance capability. I think that equation, that evaluation metric should change. That don't always look at vendor relationships on the least cost, because any slip up from your vendor or your data processor will have an immediate impact on your business. So change your evaluation criteria, make data security and data maturity one of the critical evaluation parameters and just cost.
Thank you. Mini, your take on this?
So I completely agree with what Shrikant mentioned. To add to that, probably gain visibility. How will you comply if you don't know what you're trying to safeguard? So visibility, number one, is a big do. Identify what are your personal data touch points and how and where do they exist, both internal and external. Like I mentioned, it's not just within your organization, but the external ecosystem could be more risky as far as the organizations are concerned. Secondly, of course, this is your opportunity for business transformation. This is your opportunity to optimize data within the enterprise. This is your opportunity to say, how do I consolidate processes which are probably taking the same set of data elements rather than collecting it separately? So look at this as an opportunity to maybe enhance your business. This is not just a compliance take. This is actually an opportunity to go beyond that and create some kind of a differentiation. Don't that I would say is don't take it lightly. Do not assume that if the rules are not out and hence we can wait and watch. Trust you me, there are companies who are still not compliant with GDPR, while the optics may have met it, right? So it is a hard task when you come on it, especially if you've not really thought of privacy by design at all. So please do not take it lightly. Start small, but please do make a start.
Thank you. Josefa, over to you.
Yeah, I think, Shrikant, Mini have spoken absolutely spot on. And I'm also, saying this to sound a little different, right? There has been a paradigm shift. We had data protection rules in 2011, and now, nearly 12 years after, we've got something that focused only on critical personal data or sensitive personal data. Now, the paradigm shift which has happened is this applies to even name and phone number or name and email address. And actually, it could even apply to a photo, because Google search, you can upload an image and you can get the identity of the person. So this is the expanse which we're looking at. So my immediate do is that companies need to start doing a data mapping exercise internally. In terms of most companies, there could be a possibility have never taken consent for PI, personal information, because the law never required to do so. So you would be sitting on huge corpus or quantums of data, which now kind of gets regulated. So short point, quickly do a internal data mapping exercise. And with that, the immediate correlated do is look at all your documents, your policies, employment manuals, your typical hygiene from a contractual perspective. But the don'ts, I think, are a little more interesting, right? The industry and, all of you guys, Vicky, us, and many others, we've come a long way from a 200-page data bill to a 20-page data bill. The operative part of this data law is only 20 pages if you remove the annexures. So there has been a lot of thought that it is not prescriptive. It's not an ad hoc, output. There's been a lot of thought that it's not prescriptive. So the don't out here is that when organizations are given the freedom to choose technical measures, implement security standards, we need to do it responsibly. We need to be accountable, and this kind of segues into what Shrikant said, that don't just go for just the baseline saying that, 27,000 is not written, so we'll just appropriate whatever, we'll do the bare minimum. I think overall, at a thinking level, at a governance level, that one step has to be taken. And my second don't is kind of, I agree with many. Don't wait till the implementation timelines are there, because you may just be caught napping.
Thank you. Lalit, over to you, your last words, because you're the last in the panel, but not the least. And I'm sure the questions have been flowing. You've been reading it about the deep consent. I know that Shrikant has taken that, and there are further questions being posed, but I'll come back to you on this. What are your do's and don'ts for the act?
No problem. So I think Shrikant, Josefa, and many have covered most of it. From my perspective, I see this as an opportunity for the organizations. So when GDPR came in, and when I look at it from an individual perspective as well, it gives me more comfort to do business with an organization which I know takes good care of my data. So it essentially helps, if you look at it from a point of view, it helps the organization to enhance and strengthen their business. So it is actually a business enabler, not essentially looking at a cost of compliance. So look at it as a business enabler. Have this as your boardroom agenda, so that when the leadership understands how this compliance with the law would help the organization to go the next few steps or the next few miles in their growth journey, they would be more appreciative of what the law brings to the table. The only don't that I believe is, don't treat this as a check in the box activity. The law is not prescriptive. It gives a room to the organization of how much compliance do they want to do. So don't do it as only a checkbox activity, and ensure that you do a proper due diligence and have good governance and a responsible data privacy when you're setting up processes or when you're defining your frameworks.
Thank you, Lalit, and thank you all the esteemed panelists who have joined us today. So, audience, you've heard everybody. So it's something time to act now. It's an opportunity, not a burden. Take it as a core function. Make it an opportunity where you even use it for optimization of your processes, and start acting on it. It will be an enabler for you. It will help you out to expand. It will help you out to build more linkages with the, I would say, with the companies or the countries we were looking at it. And of course, it makes India stand out well when you talk about the digital landscape. Like we started off, it completes the whole system and the digital ecosystem of India, and presents it in a very strong manner. The government has really taken a good efforts from, like Josefa also mentioned, from 200 pages, we have now reached to 20 pages, which is 10%, but we have walked a bigger distance, I would say. It's been the process which has taken 6 years, and we are finally the diamond kind of act which is in place. Now, of course, with the support of all of you, it needs to be implemented, and I'm sure government would be very much willing to work hand in hand with the industry to implement that, and that's what we are looking at. As a chamber, we are more than happy to work with you, to support you, to take your queries to the questions, to the experts, and to get back to you. So with this, I would like to end up today's session. Thank you, the esteemed panelists, starting with Shrikant, Mini, Lalit, and Josefa, for joining us today. It was absolute pleasure to hear all of you, and I'm sure, like it was for me, I'm sure it was for the audience as well. And thank you, audience, for being so engaging and putting up so relevant questions, which we could take it up during our discussions, almost equivalent to the addresses we have spent the time for the questions. So it's like 50-50. We can understand the kind of the interest the audience has in the subject and how they would love to hear about it. From Ficky's side, like I mentioned earlier also, we'll come back to you. We'll keep on announcing, and so do join us back. We'd like to thank our partners, EY and NDA, for supporting us in this webinar, and of course our co-chair for his support and guidance. With this, I would like to end this webinar. Thank you all for joining us today. Jai Hind.
Thank you.
Sarika. Thank you, co-panelists.